Hello. This presentation will culminate with force reset trigger analysis. This is a popular mechanism for the popular rifle AR-15. Let us begin. It all begins with our Constitution of the United States. Second Amendment is the battleground for those that are opposed and those that are supporting. Following through on the slides, I'll read them off with some commentary. But before I proceed any further, take due notice. This is not legal counsel for you, nor representation. This is singularly for information purposes. Duly note that any particular information you need for your circumstances and background, consult a qualified attorney in your jurisdiction within the 50 states and territories of the United States. Constitution of the United States, Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so there it is. Everything regarding firearms within these United States flow from these words and from the concept that it instills, the right of the people. With that being said, most recent ruling from the Supreme Court, New York State Rifle Association versus Bruin, Superintendent of New York State Police, decided June 23rd, 2022, and you can reach the case itself at Legal Reporters 597 US 1, 2002. This particular case was simply about carrying your firearms in open public. Ruling from the Supreme Court, the New York proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their second right to keep and bear arms in public for self-defense. And the proper cause requirement was within the state of New York, you required special circumstances, special needs in order to receive your concealed carry permit. This was abrogated by the Supreme Court in this case. Most importantly, direct language, the Constitution presumptively protects the conduct, and to justify firearms regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. Now, that is important because that has set the foundation moving forward from 2022 through now, our present time period of this video, 2024, that the government, state, local, municipal, has the burden to show that any particular regulation is in accord with historical tradition. And so here we are. The government has the burden. So proceeding on from there, we have Garland Attorney General versus Cargill, decided June 14th, 2024 of this current year of this video recording. Can be found at the Legal Reporters at 144 Supreme Court, 2022-2024. This particular case was all about the bump stock and whether a bump stock was a machine gun. Started in Texas, went through the district court, went to the appeals court, and the Supreme Court picked it up. And so, the National Firearms Act of 1934 defines a machine gun as any weapon which shoots, is designed to shoot, or can readily restore to shoot automatically more than one shot without manual reloading by a single function of the trigger. 26 United States Code 5845, subsection B. That is the standard for a machine gun, which is, for all intents and purposes, illegal without a proper registration tax stamp. So, that's relevant. Cargill alleged that the FTA, Alcohol, Tobacco, Firearms Bureau, lacked statutory authority to promulgate the rule because bump stocks are not machine guns, as defined in 26 U.S.C. 8545. This is key, whether it's a machine gun. And this case in the background was also brought under the Administrative Procedures Act, which challenges any governmental procedure regulation by an agency, whether it has the proper authority. So, ruling: a semi-automatic rifle equipped with a bump stock is not a machine gun as defined by Section 580, 5845, because it cannot fire more than one shot by a single function of the trigger. And even if it could, it would not do so automatically. ATF therefore exceeded this statutory authority by issuing a rule that classifies bump stocks as machine guns. And that's on page 415 of the ruling. So a bump stock is not a machine gun. And interestingly, in this case, the Supreme Court went through great lengths and detail to identify what is the mechanism of making a rifle an automatic, to the point that it even pointed out that the ATF in its own regulations was conflicted and in a state of confusion as to what is a machine gun, what is not a machine gun. You can view the case in detail, which brings in the idea of a pump action shotgun and its ability to, with one trigger, pull, and an action, fire multiple shots, but it still doesn't make it a machine gun. Continue on. This takes us next to all that a bump stock does is accelerate the rate of fire by causing the distinct functions of the trigger to occur in rapid succession, which is simply pull the trigger, hammer drops, cartridge is fired, reset of the trigger, and proceed once again. So repeating, all that a bump stock does is accelerate the rate of fire by causing the distinct functions of the trigger to occur in rapid succession. Now, this takes us to our most current issue of mechanical devices, the force reset trigger. This case is again brought out of Texas and will not go any further than the district court for, as I conclude in this presentation, there are very strong orders issued by the court. So National Association of Gun Rights versus Merrick Garland, Attorney General. So there you can see the case filing for the District Court of Texas, in particular, the Northern District Court of Texas. So here's where we begin. Applying the guidance from both Cargill decisions here, force reset triggers do not fire multiple rounds with a single function of the trigger and thus do not qualify as machine guns. This is the ruling of the case. And again, a force reset trigger is a mechanical device. Drop in, various brands are currently on the market in order to gain the advantage of the system. So each and every round, continue on with the course, each and every round fired, the trigger moves forward into its reset state and is depressed to release the hammer from its sear surface. Once again, direct from the case. Because the operative mechanical functions of the trigger is to release the hammer, that the trigger of a force reset trigger equipped firearm functions for each shot fired disqualifies it as a machine gun under the current statutory definition. There it is. The very idea of the reset removes it from being a machine gun. Applying the guidance from Cargill decision here is that FRT do not fire multiple rounds with a single function of the trigger and thus do not qualify as machine guns. Now here's where things get exciting. And once again, repeating, this is not legal counsel. This is not legal representation. Take due notice. This is for information purposes and commentary. At the close of the case, the judge now, by way of order, the court vacates defendants, and that is the Alcohol, Tobacco, Firearms Bureau. The court vacates defendants' unlawful classification of force reset triggers as machine guns, and I'll abbreviate to FRT. The court declares unlawful defendants' determination that the FRTs are machine guns. Now, this is powerful because vacates, from a layman's perspective, linking to legal standing, vacate fundamentally means go away. You cannot bring this back to the court. So it's pretty powerful. I'll be curious to see how the Bureau attempts to make an appeal with such a powerful statement from the district judge and the district court. Continuing on, item number 3. The court enjoins defendants, along with their respective officers, agents, servants, and employees, from implementing, or enforcing against the parties in this lawsuit any civil or criminal matter described below. The ATF's expanded definition of machine guns, that FRTs, that this court has defined as unlawful. So here we go. Here go the listings. A, initiating or pursuing criminal procedures for possessions of FRTs. B, initiating or pursuing civil proceedings for possessing, selling, or manufacturing FRTs based on the claim that FRTs are machine guns. C, initiating or pursuing criminal prosecutions for representing to the public of potential buyers and sellers that FRTs are not machine guns. And again, that's marketing. It's somewhat stated in an awkward way, but essentially, if you say FRTs in your marketing materials are not FRTs, you're safe. The Bureau must not prosecute. Continuing on. D, initiating or pursuing civil actions for representing to the public of potential buyers and sellers that FRTs are not machine guns. E, sending notice letters or similar communications stating that FRTs are machine guns. Pretty heavy stuff at this point. Very clear in the order. And F, signing or requesting voluntary surrender of FRTs to the government based on the claim that FRTs are machine guns. So this one is really important in terms of your particular circumstance with possession of FRTs. Again, no statement of counsel to you here, but simply knowledge for you to consider with your appropriate representation of legal counsel. Continue on. G, destroying any previously surrendered or seized FRTs. That's a burden on the Bureau. H, otherwise interfering in the possession, sale, manufacture, transfer, or exchange of FRTs based on the claim that FRTs are machine guns. That's another powerful statement from the court. So the basic look begins to see that the FRT mechanisms, the units for dropping into your AR-15 receiver, lower receiver, pretty much in new territory now as we move forward. Continuing on. 6, I've omitted certain items that were really linked to the litigants in the case and focused on what the court is driving and mandating of the Bureau. The court orders defendants to return all parties, including manufacturers, distributors, resellers, and individuals, all FRTs and FRT components confiscated or seized pursuant to their unlawful classification within 30 days of this decision. That's pretty powerful. They have 30 days, which is pretty much now, as we are in August, expired from the time of the ruling. 7, the court orders defendants to mail remedial notices correcting their prior mailing campaigns that warned suspected FRT owners that possession of FRTs and FRT component was purportedly illegal. Once again, this is an overview. I'm not providing legal counsel, and apologize if I'm being redundant in the statement, but it's crucially important to understand that I'm not giving legal counsel. I'm presenting commentary of what decisions have come down through the federal court system at this present time. And there we have it. Good luck, safety on the range, practice all the rules of safety with your firearms as we proceed forward in the modern era, in particular with force reset triggers. I hope this presentation was useful and informative as we proceed forward in this great nation we call the United States of America.